Hi, my name's Elizabeth and I'm the owner of Life Law Solutions. In this video I'm talking to you today about what happens when someone dies without a will. At law, this is called an intestacy, and there are two things that really need to be considered. Firstly, somebody needs to apply to the court for a grant for letters of administration. This grant gives that person authority to administer the estate. There is a schedule at law of who may apply, and this schedule is considered in priority. So the person who can apply to administer an estate firstly could be your spouse, then your children, then your grandchildren, your parents, brothers and sisters, and so on. That person needs to apply for a grant, and to do that they need to lodge an advertisement in the Queensland Law Reporter and provide notice to the Public Trustee of Queensland. After 14 days has passed, an application is lodged with the Supreme Court of Queensland. The application includes an affidavit by you or the person who's requesting to be appointed, an affidavit confirming that the advertising requirements have been met, and the formal application. These documents are lodged with the Supreme Court, assessed by the court, and then a grant will be made a few weeks later. Once you have the grant, then you have authority to administer the estate. In terms of how your property is divided, it's not automatically simply to your spouse and then to your kids and so on, particularly in circumstances where you have a spouse and children. In Queensland, the law says that if you die without a will, your first beneficiary is your spouse. However, if you have a spouse and children, then your estate is divided so that your spouse receives the first $150,000 of value plus the household chattels, and then the rest of your estate is divided equally between your spouse and your children. This is something that's really important to consider. I've run some workshops recently where people have said to me, oh, it might just be easier not to have a will because it'll just go to my spouse and then my kids. And then when I've explained to them that it's not that simple, and that really, if you've got children, it's going to be divided between you and the children, they've had a serious think about that and then considered that it might be better to have a will. If you need some assistance administering an estate where somebody has died without a will, please let us know. But otherwise, if you don't have a will, seriously thinking about getting one, go and see a lawyer who's experienced in assisting people to prepare wills, so that you don't have to be worried about what the law says is going to happen to your property. Thank you.